Good afternoon, everyone, and welcome to the webinar, First, Do No Harm, Trauma-Informed Interviewing During the COVID-19 Pandemic. Today's webinar is presented by AEquitas. My name is Cynthia Hatchell, and I'm the project coordinator at AEquitas, and I'll be moderating today's webinar. If you have a question during the presentation, please enter it in the chat box to your right. We will answer questions at the end of the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. AEquitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, AEquitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on AEquitas, please visit our website at equitasresource.org. You can also follow AEquitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Office of Violence Against Women. We'd like to acknowledge Joyce Lukema, Vice President of Services at Pennsylvania Coalition Against Rape, and Patricia Frazier of the Department of Psychology at the University of Minnesota. Presenting today's webinar are AEquitas attorney advisors Jonathan Kirlin and Patricia Powers. Currently, as an attorney advisor with AEquitas, John Kirlin worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, John has successfully prosecuted a variety of offenses, including domestic violence homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. Patti Powers joined AEquitas as an attorney advisor after serving as a senior deputy prosecuting attorney in Washington State for 27 years. During her tenure as a prosecutor, Patti supervised the sexual assault domestic violence unit in her office. She frequently and successfully prosecuted sexual assault, domestic violence, child abuse, and related homicides, which included complex litigation of high-profile and cold cases. For 5 years, Patti served as a highly qualified expert for the United States Army Central Intelligence Command, through which she consulted and provided specialized training on military sexual assault and domestic violence. I will now turn it over to Jonathan Kirlin and Patti Powers.
Heartbeat of our case. So today we're going to be focusing not only on challenges that have come about to conducting a trauma-informed interview, perhaps in a different setting or even virtually, but we're also going to be talking a lot about the opportunities that this new normal offers to all of us as service professionals to improve upon our efforts and make them even better as we strive to obtain justice for victims of sexual assault. We all know also that for a victim, there may be a myriad of signs and symptoms of trauma, which are highly variable among victims. But through the work that we've done as prosecutors and allied professionals, we've been able to focus on some commonalities of signs and symptoms of trauma. And when we do this, we need to also take into consideration that trauma may also be exacerbated by the pandemic, which forms the context of the crime in a greater sense, and also the context of the victim's disclosure when and if the victim is able to come forward and present that complaint to us. Preparing for trauma-informed interviews and being thoughtful in our approach is extremely important. We all know from our individual as well as our collective experience that the pandemic has vastly impacted life for all of us, and that certainly includes victims. And for those small numbers of victims who are able to step forward and report the sexual assault, the context of their life has greatly changed. Security that was previously there might be impaired. Communication may not be as easy or convenient as it previously would. So we need to direct our thought to trauma coming from the sexual assault and also the generalized trauma from the COVID pandemic and how that may even exacerbate some of the signs and symptoms that a victim may present. And we're going to talk in great detail about meeting a victim's needs for safety and maintaining engagement or participation. And we know again that the pandemic has changed support systems for many people in our society and has made contact and communication even more difficult. So this is the context that we all live in currently, and this is the context that we're going to be discussing as it relates to trauma-informed interviewing throughout our webinar today. And we're going to focus, as I mentioned, not just on challenges, but on opportunities that this new normal presents for literally a new beginning. There are many different considerations that come to us due to the pandemic. And first and foremost, our response as service professionals to victims needs to be as timely as is possible. We're all aware of anecdotal information from every state virtually around the country, how law enforcement is working with improving upon their responses, trying to make sure that their contact with victims is safe for victims and safe for themselves. We also know that first responders are working with improving upon abilities to communicate with victims in the midst of social distancing. And as prosecutors and allied professionals, when we have the opportunity, if not the privilege, to work with victims, we want to make sure that we're responding as quickly as we possibly can. And to do that, we all need to consider in advance what our approach is. Are we going to be meeting in an office area with social distancing where a victim may feel comfortable and protected? Or are we going to be engaging in communication through a virtual platform? Whatever that's going to be, we need to consider and plan for this in advance so that we can respond as quickly as possible to a victim. Incorporating trauma-informed practices is going to be the object of our attention at great length during this webinar. And again, what we really want to accomplish in this area, we want to be as present to victims as we always have been, being dedicated service professionals. We may not be able to have the kind of setting that we normally have, but all of us have the opportunity and the ability to be present, to be fully present to the victim, regardless of what the setting is. But it takes planning in advance, and we have to give special thought and consideration to that. Arranging for advocacy support is also part of our work. And for a victim to have access to an advocate and to that support if a victim chooses is an imperative. And so in advance of the contact, we need to make sure that we have advocacy available, whether it is office-based or a system-based professional or a community-based professional, or in many cases, there may be both kinds of advocates who are able to be present for victims. Is that going to be done virtually, or is it going to be done in person with social distancing and perhaps masks or other safety equipment? Again, we plan in advance so that our response can be timely. There has been a lot of question about the availability of medical and forensic services to victims. And around the country, it appears that there is an availability for medical forensic services, and knowing how our own communities are working with this is important so that we can assist victims in making the necessary arrangement or work with law enforcement to make sure that that arrangement is made. So what we're talking about in this particular era is advanced planning, knowing what our plan is, and again, considering the context of the COVID-19 pandemic.
So before we begin our discussion and really start diving a bit more deeply into principles behind a trauma-informed practice, it's going to be helpful to get an operational understanding and definition of what trauma is and what are some of the responses and reactions to trauma. Initially, what we want to do to start this conversation is distinguish trauma from stress, because sometimes those two terms can be used interchangeably. Sometimes trauma is misunderstood just to be simply stress. And in the sense that a lot of people who aren't informed or maybe aren't up to date on best practices or the best information, they might operate under a misconception that trauma is something that can be controlled by the person experiencing trauma. And in this sense, it's probably one of the most significant distinguishers from stress. Trauma is something, an extreme aversion that happens because of a stressful event, something that in some way the mind or body is trying to adapt to and can't recover from on some level, and makes adaptations to try and accommodate whatever that traumatic memory is. Now, as we're going to talk about, how that specifies varies between the individual based on their life history, their life experience, and the nature of the traumatic event. But the responses or reactions to the traumatic event lingers and continues long after the trauma, the event that caused the trauma is concluded or no longer ongoing. This is distinguished from stress because stress happens. It might cause physiological reactions, emotional reactions, or mental reactions, but when the event is over, then the stressor is removed. A good example is even just from the beginning of this webinar. Myself and Patti and Cynthia, when the sound wasn't quite working and the internet connection wasn't quite connecting, that was a stressful event. After a couple moments, it self-corrected. We were able to talk to you about all the important housekeeping things about the webinar and content today you were looking so forward to. And that stressor of the audio or the sound not working was removed. None of us are going to be living with that stressful event after it concludes. After it's concluded, none of us are probably going to be having flashbacks or anything like that. It's not going to be affecting our outcome or our bodies in ways we can't control later on. This is distinguishable from stress, or from trauma, excuse me. Trauma actually also has a clinical definition, and it's useful to reference that because it gives a good context for what we're talking about, the unique significance of trauma and understanding trauma. And here's a definition from the American Psychological Association. Trauma is an emotional response to a terrible event like an accident, rape, or natural disaster. Immediately after the event, shock and denial are typical. Longer-term reactions include unpredictable emotions, flashbacks, strained relationships, and even physical symptoms like headaches or nausea. These sort of responses and reactions in the individual, and these reactions, it's not volitional. And that's critical for premising our approach, a trauma-informed approach, when we're working with victims who've experienced trauma and may be suffering some of the impact and effects of trauma.
These are some of the common reactions to trauma that we mentioned earlier, bearing in mind that they may be highly individualized among victims, but these are the common expressions that we all frequently see as prosecutors and allied professionals. There may be difficulty making decisions. And in fact, when we look at this aspect of reactions or behavior, we have to also consider the pandemic that's taken away previously known support systems, for example. Flashbacks or preoccupation with the experience of the crime may also be common among many victims. There can be memory disturbances. We know that interviewing really is a process, and we'll be talking about this as we develop our conversation during this webinar. But we need to bear in mind that there may be times where a memory is simply too painful for a victim to draw into a stream of consciousness. And this may make an interview difficult given when it is. There could be changes in hygiene. Many times there can be a sense that things aren't real. Victims hoping against hope that perhaps this didn't really happen. And all of us have had cases where victims have contacted offenders after the crime or the days following the crime, again, hoping against hope that somehow they'll learn that this was a horrible nightmare. So there can be a sense that things aren't real. And we need to draw this into the perspective of the pandemic as well. So much in so many of our lives has dramatically changed. And this is the same for victims. And it really can exacerbate common reactions to the trauma of the infliction of sexual assault. Worrying, changes in sleeping and eating, or being withdrawn, feeling unable to connect. These are just a few of the common reactions to trauma, again, that we want to put into the perspective of all of the changes that have come about in the victim's life in terms of the pandemic as well. Some additional responses to trauma, and we're all familiar with these from our work as prosecutors and allied professionals. There may be inconsistent or sometimes piecemeal memories. We all know that trauma literally destroys a chronology for a victim, where a victim would not be able necessarily to remember the first thing that happened, the second thing, or the third thing, but certainly can recall what the experience of the crime was. Delayed disclosure is almost the norm as we know it in sexual assault cases. Sometimes the impact of trauma is as such that a victim is literally unable to make that report. And John and I will be discussing the word able, which takes on a golden meaning, if you will, when we talk about laying the infrastructure for trauma. Self-blame. How many victims that we all have worked with throughout our service as prosecutors and allied professionals have blamed themselves. And that takes us then into the consideration of societal myths and misconceptions that sometimes have been victim blaming, assumption of risk, which we've heard of as an example of this. But victims very frequently blame themselves, and this may also impact our opportunity to ask questions related to the crime. Some additional common responses that we've seen: minimizing in an effort to somehow cope with what's happened. Well, it couldn't have been as bad as I thought it was. These really represent responses to trauma where the trauma is so great and so overpowering that a victim is literally trying to minimize in an effort to be able to cope and to continue with a semblance of life as she previously knew it. Continued contact with the offender, again, hoping that it didn't happen. Trying to return to normal behaviors. This becomes vastly challenged in the context of COVID-19, because what was normal before may not be normal any longer simply because of the pandemic, and then with the overlay of the sexual assault. This may represent a huge challenge in terms of trauma for a victim who's able to make that report. Sometimes victims are unable to maintain their engagement in our efforts in the criminal justice system. And many times it's because of the trauma of the event that is so overwhelming and so overpowering that it becomes painful to become involved in interviews and the many different facets of our work that we ask victims to help us on with. And then we get to the ultimate withdrawal, and that's recantation, where it simply is too difficult, too overwhelmingly painful to be able to proceed. And so when we look at the common responses to trauma that we're just touching upon at this point, there are two things that we need to do. One of them is to put it in the context of the pandemic and the impact of COVID-19 on the victim's life, and also at all times maintain laser-like focus on this, and that's that the offender caused victimization and is responsible for the infliction of the trauma that we're seeing.
The other point that's critical to remember as part of a trauma-informed approach, though, is that the reactions to trauma and what shapes the responses to trauma, it's not occurring in a vacuum. It can be subject to other influences that are happening independently and or simultaneously with the trauma of the traumatic event. And here's a visual of some of those examples, all sort of working holistically to create responses and reactions into the victim. So while we have a great sort of review or discussions about the range or the spectrum of responses and reactions victims can exhibit in response to trauma, those responses and reactions can be shaped by other factors as well, either independently or in combination with that person's reaction or response to trauma. One of these examples, and we'll focus on the two biggest wheels right here, is going to be substance abuse and how that's going to affect someone's response and reaction. Or if there's mental health or mental disability issues, it's also going to be impacting responses or reactions as well. Specifically with COVID-19, someone's ability to disclose or participate with authorities or with the investigative process in the criminal justice system, that can be shaping someone's ability to disclose, like, oh, especially if it's an intimate partner type of incident or violence. If I disclose right now, or if I talk to the authorities, if I report it, am I going to lose my home? Am I out of a job and maybe I'll lose the only breadwinner? So there's going to be that impact as well, in addition to the trauma. There could also be just explicit intimidation between the offender and the victim as well, shaping some of these reactions and responses and ability to participate in the process. So we're spending a lot of time talking about how to adopt a trauma-informed approach so that we can listen to our victims and learn from our victims. Part of that is also understanding that there's a lot that's going into our victims' responses and reactions and how they're able to participate within the process. And we have to be open to all of those explanations so that we can learn to work with them rather than an expectation of our victims trying to adapt to our needs and what we would expect. But the impact of trauma can vary. It varies from it can have a tremendous impact on memory. And there's a lot of studies and discussion about this, but at a minimum, I think most of the studies would agree that trauma can impair memory. It can impair memory either by causing either disorganized memories, reduced memory, maybe some inconsistent memories, or non-retrievable memories. And the theory about this is generally because when the body a person is suffering the shock of a traumatic event, of what on some level might be viewed as a life or death situation, chemical changes are occurring in the brain, occurring in those parts of the brain, the hippocampus, that organize memories and store memories. Part of that, the theory is that it can be a natural survival skill and defense mechanism, so a person can just focus on what's necessary to manage or get through the traumatic event. But again, this can be in combination with a variety of factors as well. It's also important when we're working with victims of trauma to recognize the impact and effect of previous trauma, because often we have victims who are picked and selected by offenders because of their vulnerability. One of those vulnerabilities is going to be an offender recognizing the damage and vulnerability a victim might have because they've been previously traumatized. And maybe if that trauma, previous episodes of trauma have never been addressed or resolved or looked at, it's going to be impacting the victim's life and how they deal and experience the world in different ways. I'm not trying to say there's a categorical way in which victims with unresolved trauma respond or manage or react to that. But on one level, when it's known to offenders, that can make them more vulnerable to the offender, and that can be utilized by offenders as well. And so we want to understand that when we're dealing with victims who've been repeated victims of trauma, if some of their responses or reactions might be initially difficult or challenging for us to understand, we want to keep our mind open to the possibility that maybe some of that's shaped by previous trauma. Maybe some of that previous trauma is understood either on an explicit or implicit level by an offender when they were devising a way to perpetrate their crime against this particular victim. Disclosure, when we do receive it, because it's a challenge for a victim to disclose, especially burdened and handicapped by trauma. So when it is received, we want to recognize that the effect or impact of trauma is going to mean that that disclosure, it just doesn't happen in one event or one bang or flash of light, but more often than not, trauma is going to force the disclosure of the traumatic event to be a process over a period of time. And we'll talk about some of the methods to accommodate that process and to put victims in a space where they're able to participate and disclose more fulsomely on their terms and according to what they are able to do at a given time. Of course, also, disclosure can also be impacted by impaired memories, which can also be affected by alcohol and drug use, which is going to impact and impair an ability to recall memories. What's important to remember, though, is when we understand this initial principle is that disclosure is going to be a process, not a single event, is that we aren't going to want to be forcing victims to fill in details. Because when there's gaps or holes in their ability to disclose, trying to force them to fill it in is going to fill it in with details that might not be as reliable just because of our impatience. Someone who's done a lot of great lectures and studies on trauma and is worth, there's some great YouTube videos of her, and I recommend you look them over, is Dr. Becky Campbell from the University of Michigan. She has a great statement about this process, about disclosure and the impact of trauma, is that, quote, "The story can come out in bits and pieces and fits and starts and cycle back over on itself." Or a victim might say, "Oh, wait a minute, I remember this detail." It comes out in a very disorganized way. Now, this doesn't always lend itself to maybe how we were trained to envision an investigative or prosecutorial process where we want a clear, consistent temporal narrative and chronological timeline so we can put our case together. But again, one of the big principles of trauma-informed that we're going to be going to throughout this presentation is that trauma-informed is adapting ourselves to the victim rather than expecting the victim to adapt themselves to us. Part of the, I think I mixed up which slide we were handing off here. Yeah. The other thing we want to remember, though, is that,
I'm sorry, I was on mute. I apologize for that. This is the reality. It's the offender who inflicted trauma on the victim. So all of the manifestations that John and I have been talking about, we need to keep the offender in the picture. Just like we began, our attention is directed to maintaining a victim-centered and offender-focused approach during the pandemic. And this is part of the reality, the offender's responsibility for the trauma that we're seeing in our work as prosecutors and allied professionals. So the next question, and it would be wonderful if we were all present together to discuss all of the different ways that you're bringing a trauma-informed interview to reality in the context of the pandemic. But what we're going to be discussing in this area is utilizing current office space or current locations with social distancing, and perhaps also with the usage of masks. And in other locations, there's been more of a focus on virtual platforms such as Zoom in an effort to bring virtual reality to this very important communication during the pandemic. So we're going to be looking not only at what it looks like, but we're going to be talking about strategies to make this as real and effective as is possible, even given the change in our circumstances. And this, first and foremost, is the precept that guides all of our work. First, do no harm. And John has made a great point earlier of saying that the victim should not be in a position to accommodate herself to our needs, but in looking at this more clearly and more closely, this is part of our work. This is a victim-centered approach. And the last thing that we ever want to do is to re-traumatize the victim. So we have to engage in a very thoughtful approach, given the indicators of trauma that we're familiar with, given the possibility of prior victimization. And when we talk about prior victimization, we're talking about a serious vulnerability which an offender, an intimate partner, violence, sexual assault, or an offender who knows the victim might even be preying upon. So we want to make sure that all of our efforts are guided by this precept of not causing any further traumatization. So looking at trauma-informed practices, first and foremost, as both of us have been discussing, we want to make sure that we are satisfying the victim's needs. Not all victims may be in a position to be able to articulate, for so many different reasons, what their specific needs are. But we know from our experience as prosecutors and allied professionals that two of the chief needs are privacy and, secondly, safety. And these are almost interwoven for victims in terms of the needs and what they desire from us in terms of our support. As John mentioned earlier, I was privileged to serve as a senior deputy prosecutor for 27 years, and I specialized primarily in sexual assault cases, domestic violence, and related homicides. And in speaking and being privileged to speak with so many victims of sexual assault, I learned that for many victims, this is a crime that does not end, but it is the victim's experience that it goes on and on. Many victims felt like that day or night or that event was almost frozen in time and returned to it so many times in terms of their stream of consciousness. And so safety is not only a physical consideration, although that certainly is important, but it also is a psychological consideration. How do we meet these needs? We meet these needs by anticipating questions that a victim may have that a victim may even be unable to articulate. So many victims are listening to different broadcasts and are involved in internet research and are coming to see that there is the spread of COVID-19 in many jails or departments of correction. The immediate question that most victims are going to have is he going to be released? Is he going to be getting out of jail or out of DOC? I've heard that they have COVID-19 in the population and that they're trying to release a lot of people to stop that. So we need to have that answer. And we also need to have the commitment that we will be advancing the victim's safety with objecting to bail unless there is an urgent reason that would somehow be out of balance with the primacy of the victim's right to safety. Prioritizing a victim's right to make decisions is important. As we all know, this is a crime in which the victim had self-determination and choice completely taken from her. And so at every opportunity, we need to restore decision-making to the victim in terms of when our meetings should be, how often we should meet, whether the victim wants to have notification from us as prosecutors or service professionals about different proceedings that might be coming up. Whatever those proceedings are, we need to make sure that the victim has the opportunity to engage in decision-making with us. And of course, safety is important at all times. And we need to bear in mind too, that even if we're discussing doing our work in a virtual setting, safety is still important, both physical and psychological. The victim needs to know where the offender is, if the offender is still in custody, and the victim needs to know that we're mobilized as multidisciplinary teams or with strong working relationships to be supportive at all times during the process. And this is important too. If victims believe that their disclosure, which was so very difficult to do, given trauma and given what this crime has done to a victim in the middle of a pandemic, if they believe that they are going to have greater harm occur, then they may not choose or be able to reveal their situation or to maintain their engagement in the criminal justice system.
That last point, and just if I can build on what Patti was saying there, it's such a great sort of embodiment of the dual utility of a trauma-informed practice, because on one level, and the victim-centered level, a trauma-informed practice, it's nicer to the victim, it's more empathetic to the victim, it's helping them hopefully find a way out of this trauma that's been created by the offender. The offender-focused perspective of using a trauma-informed approach with the victim is by doing it, we're also more likely to have a victim who can participate within our process, participate in our cases, and help build stronger cases than if we're not using trauma-informed practices with our victims and interacting with our victims. And that sort of segues nicely into our next point, where we want to talk about interview considerations about a trauma-informed practice. And trauma-informed practices, on one level, it lends itself really well to the unusual circumstances that the world of COVID-19 has created for us in the criminal justice system. Because what a trauma-informed practice is, fundamentally, it's not so much a series of steps or outlines or a process. It's more of an approach. It's an approach informed by an understanding of the variety and spectrum of responses and reactions that victims and people can exhibit in response to a traumatic event. So when we talk about this interview consideration about how do we, when we have our trauma-informed interview or meeting with the victim, what does that look like? A lot of it is going to be shaped by the circumstances or context of when and where we are meeting with the victim, who we are as the individual in the process meeting with the victim, where this meeting is happening, and how we're accomplishing this meeting. So for example, what we mean by this is a trauma-informed approach. What's going to be trauma-informed practice with an initial responder, maybe a first responder in uniform who's responding to the scene of crime, is going to have different demands and different applications than maybe what's going to be happening if an investigator or detective is having a more complete or fulsome interview later on, or as, and I don't know how much of the audience are prosecutors, or when we are meeting with our victim for purposes of preparation of court or actually examining them in court. And so these are all going to be events shaping it. But a lot of what it is on a basic level is what are we doing in the context in which we are meeting with the victim and who we are as our place in the system. What are we doing to help this victim feel safe and help this victim feel comfortable? So on one level, with the concerns about COVID-19 and the pandemic and being exposed to that, a good trauma-informed approach, maybe if we're meeting with our victims before trial or before court, is usually you don't want something as impersonal as a Zoom meeting or virtual meeting. You want to get them a chance to be comfortable with you and you get to know them and adapt yourself to them. But maybe with concerns of COVID-19 and that sort of impact, it's making that form available. Hey, let's set up a virtual meeting. Let me set it up at a time when maybe you're available to talk, when you're not tired from just having finished your shift at work, where I can talk to you and you can talk to me. Yes, in a perfect world, we could meet in an open, comfortable environment, but trauma-informed is adapting yourselves to the circumstances and what the victim needs to be able to feel safe, to feel comfortable, and to be able to communicate with us either as investigators or prosecutors or advocates. Now, social distancing requirements and recommendations and practices present some challenges to this. Because one of the principles we want to incorporate into a trauma-informed practice on any level is some sort of rapport building. That's difficult to do or more difficult to do during an environment requiring social distancing, but it can still be done. And the principles behind building this rapport is pretty important because not only is it hopefully a device to help make the victim feel more at ease, more comfortable, and more safe, but a good rapport building, it's going to help us understand how the victim is able to communicate or where they might be having challenges in communicating, how we might want to sort of reposture or reposition how we're explaining different things that might happen within the process or in the case based on what the victim's level or ability of understanding was demonstrated during a period of rapport. So rapport is helping us to understand the victims as well as helping a victim feel safer and comfortable. And it can be done even with social distancing, hopefully with even if you're having virtual meetings or something like that, and talking about it with the victim about who they are, how they're handling things, and maybe just talking about events and circumstances beyond the scope of the traumatic event. So one of the ways in which we can do this is we also want to provide opportunities to make sure that we can link in advocacy support and private communication. And this advocacy can support, it can either be system-based, maybe something in our own police agency or prosecutor's office, as well as our community advocate's office. If we're meeting with our victims prior to court and using an audio or video telecommunication platform such as Zoom or something similar, one of the things we want to have a conversation about or an understanding about as a practice is whether or not to record that interview. Generally speaking, I'm not here to recommend what the practice should be for a preparation, whether or not to record an interview. But one of the reasons that we want to be thinking about that is because if we're meeting with them over a platform that has that sort of video and audio sharing technology, the capability to record it is going to be readily available. So if we don't, that's going to be something that might be examined or questioned later on. So if we're choosing not to do it, we want to be able to know why. And maybe this can be a conversation, because part of trauma informed is going to be making sure victims are fully informed, that we have this conversation with the victim about recording, why we might want to record, so that hopefully we have a record of what happened, what the consequences can be of not recording, and getting a victim's informed and empowered input from that. And of course, we also want to remember, is just as in pre-COVID times, if something could be characterized as work product, and I'm speaking more as if we're prosecutors here in this context, that's still going to be applying to case preparation. And so we also want to be confident, certain of when we're meeting with victims and the context in which we're meeting the victims, the purpose of which we're meeting with the victims, if it's just to get to know them, if it's preparing for court, if it's to learn about actual evidence or facts in the case, things of that nature. So what are some basic ideas behind recognizing trauma recognizing trauma and strategies to adapt to it? Well, some of the things we need to recognize about trauma, the same things we've been talking about since the beginning of this presentation, is trauma affects victims' perception and responses to events. Now, it affects the perception and responses in a variety of ways, and sometimes in a spectrum of ways. Trauma might be impairing, trauma and other factors may be impacting or impairing a victim's ability to participate in the case, either through inability or challenges in disclosing, or maybe whether or not they can participate in actually preparing for the case and or testifying. Trauma is going to be influencing the victim's memory, both the organization of that memory and the ability to remember. And what we also want to remember is that all of these challenges caused by trauma, it's not the victim's fault, but it's something caused by the offender that perpetrated the trauma. So what we want to do is we want to make sure our practices can adapt and individualize themselves to that victim. And we don't want to be doing this in silos, but we want to be working with other disciplines to make sure that we have a multidisciplinary approach to trauma-informed practices. This means working with our allies in advocacy, system-based and court-based, or allies in law enforcement, in the medical field, as well as prosecution as well. And most importantly, make sure it's individualized to each victim. So I'm going to offer this, and again, having just discussed the variety of ways and manners and shapes that a trauma-informed practice can happen, I want to focus mostly on, right now, on how that can work with a prosecutor meeting with a victim and preparing a victim for a court case as it proceeds through the process and through the system. How can this be prepared for? And this is generally rather than categorically. One of the things that's going to be critical for this trauma-informed practice from a prosecutor's perspective is preparing for this interview and meeting before we even meet with the victim. And at a minimum, that's going to be reading reports and witness statements, hopefully talking to the responding officer or investigator, reviewing as much of the case as we can, reviewing the 911 tapes, not only so that we understand the evidence as best we're able, so that we're in a position so we can start thinking about how we're going to adapt ourselves to the victim, how we're going to adapt our approach to the victim. Part of that, reviewing the defendant's criminal history. One of the things that should set the antenna up is if we see an extensive criminal history from the defendant, either with this victim or with other victims, I want to be alert to the idea that, one, the victim might have a rational and good reason to be afraid of this offender, and might also, on another level, have been intimidated by this defendant, and that's going to be impacting the victim's ability to participate. We also want to be aware of any vulnerabilities of the victim as best we're able, and of course this is going to be an ongoing process, but the kind of vulnerabilities, and this is good strategy throughout the case, not just as a trauma-informed, but to thinking about how we're going to be, how things are going to be framed with a jury or fact finder, being aware of the vulnerabilities of the victim, whether it's going to be maybe a disability, maybe there's going to be a use of alcohol, maybe it's just going to be someone who an offender believed wouldn't be believed by the police or by a jury or by us in the prosecutor's office. But being alert to that, because when we're aware of the vulnerabilities of the victim, you can bet that these are vulnerabilities that an offender already identified, and then an offender had a plan or plot to exploit, to perpetrate whatever the crime is. Let me get the graphics up on this rather than wait for the animation. Now, we talked earlier about disclosure being a process, not an event. And part of that is that with our initial interview, we want to keep our goals defined and maybe just the first throughout a process. And part of that purpose of that initial interview is not going to be finding out everything we can about the case and the facts necessarily, but it's going to be about building this relationship, building our relationship with the victim, and on some level, building their relationship with us. Getting to know them, building that rapport to make them feel comfortable, and so that we can learn about the victim and how they communicate. Trying to recognize that the victim is coming to us or meeting with us, probably in a context where, as a prosecutor, they're viewing us as a person in authority. They're coming into our office, perhaps in the courthouse or in a government building. They're meeting with us. They're going to receptionist desks. Most receptionists in most prosecutors' office are going to be behind what's assumed to be bulletproof glass. We come out dressed as a business professional. There's an uncomfortable power dynamic to most people in that situation. And that's something we want to try to de-emphasize, so that hopefully we can start just communicating like two human beings with one another. Part of this is also going to be educating the victim, and educating the victim in a context and in a way that's going to be digestible to that victim through what we've learned through a rapport building process. Because ultimately our goal in educating the victim is going to be that how the decisions are going to be made in the case, that a contributing factor to our decision as prosecutors is going to be shaped by a victim's informed input. And the individual or person's job it is to inform that victim is going to be us, the prosecutors, to educate that victim, to make them understand the trade-offs and the costs benefits allowed, so that when we're deciding what to do with the case, it can be backed and supported by that victim's informed input. Another thing, it might be more sort of housekeeping or administrative too. We want to be sure with a victim we get contact information. And in these days, of course, and this is old practice, it's usually not just going to be a phone number that may or may not be available in the months that a case proceeds, especially if disposition of cases is going to be delayed through COVID-19 backlogs, but we want to make sure we have ways to get in contact with the information that depends not just on phone numbers, but maybe social media contact information, maybe an email address, maybe an individual who the victim represents to us and permits us to contact that will always know where the victim is, whatever their circumstances, whether it's a family member, close friend, or whoever. But we want to try to get this background. But ultimately, for this initial interview, it's the primary goal is to just build this foundation and then get a second interview where we can meet and start building out from that.
So developing trust and rapport, this really does relate back to what John mentioned just a few minutes ago, how important it is to thoughtfully prepare for this interview. And I recall one of the things that really stood out from the experience I've had with victims. So many victims would advise that they didn't think anyone would believe them. And it reminds me again of what a predator does in committing the crime. It's based upon a victim's accessibility, and that can be in a relationship, an acquaintance, or it can be someone that is a friend or is known through a social setting, but there's some kind of accessibility. The second component is that of vulnerability. And in particular, when an offender knows a victim, the offender knows what the victim's vulnerabilities are. Maybe a victim had previously been in alcohol treatment or drug treatment. Maybe she's coming from a broken relationship. There are a myriad of different vulnerabilities that victims may have. But when they're known to the offender can use this vulnerability to achieve the third component, and that's credibility. And it's not how we all look at credibility, because we accept the credibility of the victim. But an offender believes when there are certain facets of vulnerability that the victim is not going to be believed in our communities. Alcohol is a good example of that. So we need to very, very carefully prepare when we begin the interview to establish the trust and rapport that is so necessary to our ability to give the victim a true opportunity to describe the crime. Acknowledging trauma is important, and especially trauma that has occurred in the midst of a pandemic. So many lives have been altered and changed through the impact of COVID-19, and the victim certainly has had that occur as well. But letting the victim know that we can understand the trauma that has occurred is the very beginning of establishing rapport. And it's good for us to express our belief and our understanding of the crime, and also an understanding of what kind of courage it took for the victim to be able to report. We know that sexual assault is a vastly underreported crime, particularly when the victim knows the offender in any degree. And we know that very frequently the crime is not reported due to the impact of trauma or perhaps threats made by the offender. So what it's taken for a victim to be able to come forward, to make that choice, to make that commitment to engage in the criminal justice system is a huge, huge indicator of a victim's courage. And that is something that we certainly can express. We can make promises that we keep, and that means doing everything possible, exercising our best efforts to hold the offender accountable. Sometimes a victim will have concerns about various aspects of the case, and I'll return to the example of alcohol, because that usually is a concern that victims express when intoxicants have been utilized during a sexual assault or during that period of time. One thing that we can tell the victim is that the victim is believed. We're making the commitment to bring this case forward to the best of our ability. In terms of alcohol, this was something that the offender used against the victim in many cases to get the victim not to make the report, because nobody's going to believe you. You were drinking. The police aren't going to take your call. Well, we have answered the call. We have proudly taken the disclosure, and we're able to advise the victim that the commitment that we're bringing is to recreate the true reality of this crime, ultimately for a jury, if this case does not resolve to the satisfaction of the victim and to our jurisdiction. We know that a victim's life has changed greatly because of the pandemic. Support systems that were previously in place may be altered by the inability to communicate as easily, or sometimes by restrictions on even being able to go out to associate with friends or other members of a support system. So we need to factor that into our consideration as we begin relating to victims. And what I'm reminded of really is our understanding as prosecutors and service professionals, and that's that we're all in this together. We have shared humanity, and what we bring to victims is the respect that we have for all victims and for the work that we're privileged to do in the criminal justice system. Sometimes it's good to talk about general topics if that's something that fits well with the victim. Sometimes we may be working with a victim who is so fearful about having taken this first step to disclose, or coming to our office, or coming to a virtual platform to be interviewed. They may simply want us to address what the issues are that brought them. So again, a trauma-informed approach also requires us to be flexible and adaptable to what the victim's needs are. Having a candid conversation is very important. And I think during this discussion, it's so important for us to be ourselves. That's the reality that we want to convey to victims. Not simply, I am a prosecutor, but I'm the person that I am. We do have commonalities. We're in a pandemic together. We're all trying to accommodate change. And we respect the fact that you've advanced to this point to find the courage to come forward to discuss this crime and what happened to you. We'll try to make a victim as comfortable as possible, and whether that's done in a restricted social setting with social distancing and safety equipment sometimes, or whether it's done virtually, we need to be fully present. And what I mean by that means putting other things aside, not worrying about the next concern that's going to present. If it's going to be in court, or a meeting with another victim, or a meeting with another professional, that needs to wait. We need to be fully present in the moment, because if we depart from that, we're going to be missing things that are very important, whether it comes to us from demeanor or whether it comes verbally from information that the victim is sharing. We need to also discuss with the victim our goal, as I mentioned earlier, of recreating the reality of this crime. Only the victim knows the true reality of that case. But as trained professionals who are able to identify trauma and who are able to understand how trauma manifests itself in an interview, by doing this work, we're going to be able to, at a later time, explain this to a jury. We had a great question come up earlier from one of you, and that is, how do we convey all of the impact of trauma to a jury? What is the means to do this? And I believe delayed disclosure was an example. In so many cases, it begins with our examination of the victim. Were you able to talk about what happened? No, I wasn't. Was there a time later on when you were able to mention this to someone? Well, I was, but it took me a very long time to be able to talk about it. Are you able to tell us why that was? I was scared. I thought something bad would happen to me if I ever told anyone. I worried that he would come back. How many times have we heard this from victims? And sometimes a victim can eloquently explain, and I just use this one example from a victim, can explain this trauma and the impact of trauma on the witness stand. Other times we may ask for expert testimony to also explain delayed disclosure. Sometimes police officers who are experienced in the area, or advocates who are not assigned to the particular case and who are very familiar with delayed disclosure and how this comes about, can also explain this to a jury. But it begins with the victim, with the impact of trauma. And we want the victim to feel empowered, if you will, to provide all of the details of the crime to us. And many of those details are very difficult for victims to share, But again, going back to the rapport that we've been able to establish, the shared humanity, our ability to identify and to relate to trauma and to respect the dignity of victims and the great courage that it's taken them to come forward can actually encourage and support victims in the sharing of all of these details. Sometimes details may be as such that they aren't necessary for the fact finder to have, that they're irrelevant or they are more prejudicial than probative. And we can certainly explain that to victims as well. These are questions that many victims have. Are they going to know everything about me my entire life, everybody that I've ever been out with? How much do they get to know? And we need to be in a position to answer that and about what we can do as prosecutors to direct the judge's attention to information that is not relevant or probative and should not be provided to the fact finder. And the truth is what brings us all together. And that is at the core of our relationship with victims and with other service professionals, with juries, and with other members of our community. So when we talk about an in-depth interview, this may take more than one session. And again, we need to be flexible. We need to allow victims a true opportunity to discuss and describe their experience of the crime. Sometimes waiting for an interview may be a good idea. It may be that a victim needs some time to deal with what's really a life-altering change and to try to accommodate to any extent the trauma that's already occurred. Sometimes some other victims may want to have an interview done as soon as possible, fearing that if they have to wait very long, maybe they won't want to do it. So we have to be flexible and determine when we're going to do the initial interview. And it's a process. Many victims disclose in layers. Sometimes a victim will share initial information, and then later on, if a comfort level is achieved, to use that terminology, a victim may feel that it is safer to provide additional information. And at every point along the way, the victim is impacted by trauma and is returning to that crime when we're asking questions that draw the victim's attention to any aspect of the crime. At every point in our contact with victims, we're also going to be focusing on physical safety as well as psychological safety with updates on custodial status. Many victims, as I mentioned earlier, are very concerned that the offender is going to be released because of the presence of COVID-19 in many penal facilities. So we need to make sure that a victim is updated at all time, and then we have a good interface with the Department of Corrections so we can advise if there are any issues at all. And we'll be gathering information from the victim during the course of the interview about the offender, about the history of that relationship or acquaintance, about other persons that the victim may have seen after the crime. And we refer to these as secondary witnesses. Even though hearsay may not be admissible in certain circumstances after the crime, how a witness encountered the victim, the changes in demeanor and attire and hygiene can also be probative of trauma and may provide us with very important information. Determining whether to record or not record is also an important consideration, and especially if we're doing virtual interviews during the pandemic, these will generally be videoed and recorded. The rules of discovery still apply to them. Work product is generally excluded, but in terms of a victim's comfort, we need to have the answers and to the questions that may not even be articulated about what will happen with this record when we're speaking to the victim. The important thing is that we're fully present to the victim throughout the interview, not distracted by notes, but able to concentrate and focus and be fully present, whether this is done through virtual software or whether we're in the same office. So looking to corroboration, one of the things that we want to bear in mind is that when we are recreating the reality of the crime, we're not talking about the crime itself exclusively, but we're talking about the context. And it's almost like taking a large rock and tossing it into a creek. The rock may go down, it's going to hit the bottom foreseeably, but all of those ripples that go out are actually very important to the context of the crime. Was anyone present at the party at whatever location this was, whether it's an event or maybe it is a social gathering? Who all was there? We're going to want to talk to those people in our investigation. And after the incident occurred, where was the victim able to go? Was she able to call for an Uber? Did she leave? Did she go somewhere on foot? Was anyone else involved? Did anyone come to assist her and try to provide her transportation to leave? Whatever that was, we want to again examine the context and all of the persons that may have very valuable information. Was there any outside communication? Was the victim able to text anybody, for example? Did the victim call anyone? Was the victim attempting to contact a bystander? Whatever that was, we want to try to identify those individuals because the information they can provide us can give us timeline information. We may also have an excited utterance due to a statement made by the victim while still impacted by trauma. Were there any photographs of injuries involved? Did the victim take any photographs before reporting to law enforcement, especially if this is a delayed disclosure? And again, was any media used by the offender during the sexual assault? Sometimes there will be videos, sometimes there will be social media communication. Whatever that was, if the victim saw something or thought this might have been going on, that's also going to inform our investigation as well. And finally, did the crime take place at or near a location where there may have been surveillance? If there was, we all know from experience how quickly we need to make that request. Very, very frequently, if the request is not made nearly immediately or as soon as possible, those videos can sometimes be discarded or recorded over, and we may not have important information. So we're looking to every aspect of disclosure that we can find to corroborate the victim's corroborate the victim's disclosure, the victim's testimony. Acknowledging belief and understanding to a victim is important, and we all do this in different ways. And this can come sometimes through a nod of the head, if that's natural to our communication, or it can come verbally through expressing our understanding. But it has to come from us. It has to come from us as authentic individuals, not just as prosecutors or other service professionals, but the people that we are and what it is that we bring to our profession. And this natural communication is more important to victims than any other discussion that we can have. Letting victims know that we share their concerns and understand them and respect them for what they're saying. This kind of affirmation is critical to maintaining rapport with the victim and also supporting the victim's continued engagement in our work in the criminal justice system. Reflective listening is another area that's very important, and this also carries through to our direct examination at trial. So by reflective listening, we mean repeating either a phrase or the core of information that a victim is providing us. And a victim may tell us about various aspects of the crime, and we may then restate what the victim has said. You know, the experience that you've described to us was terrifying. And you told us in so many different ways how every moment that you were with the offender caused just incredible fear that you felt. It shows the victim that we're listening, and not only are we listening, it shows the victim that we are hearing and understanding and respecting. And it also validates those statements that a victim has made. And sometimes simply by reflecting the information that a victim has provided, That allows the victim to hear another person's statement and sometimes to even understand it better and relate to it better when it's said by someone else. On the witness stand, when we call the victim on direct examination, this may lead to what's called double or triple direct examination. You told us that the first thing that you were able to recall after he forced you into the room was how the lights were suddenly turned on. Yes, that was what I initially recalled. Well, after the lights were turned off, are you able to tell us what you next recalled? And then the victim can respond to that. And what we're doing is restating basically the core of what the victim has told us. We're using it as foundation for the next question. And we'll have some other examples of that later on as we go. But it comes back to our ability to be fully present and not just to hear, but to really listen so carefully to what the victim is saying. We can provide the victim invaluable support through reflective listening and later double and triple direct at trial. Many victims present from a myriad of different cultures, and language in one culture may be different than language that is used in another culture. And some victims may or may not use language that is typically used in situations describing sexual assault. We need to be flexible in our understanding of cultures as well as any language choices that a victim may make. There may be language that cannot be used, like sex or victim. These may be words that could bring dishonor in some communities. And so we've got to be careful to understand that, to be sensitive to cultural needs in discourse and communication, and then also to ask the necessary follow-up questions that we need to. Sometimes victims will try to clean up or change the language that they would use out of respect for the situation and out of respect for the work that we're doing. So we need to ask that other question. When you say, as an example, he had sexual intercourse with you, are you able to explain what that meant? And a victim may respond using the very language that she might have avoided, describing a very violent and unconsensual act of rape. But again, listening and hearing and coming to know a person for their cultural aspect, being sensitive to that is critical to the work that we're doing. Let me just mention very briefly, sometimes victims will even use terms of art. He tried to stick his private into my mouth is an example that most of us have heard before. And then when we're talking with the victim, we come to understand that that was a completed act of sexual intercourse. He did stick his private into her mouth. We've heard the word tried to so many times, it almost has become a term of art. He tried to rip off my clothes, or he tried to throw me on the bed, only to find out that those were completed acts. And we often wonder if the tried to somehow manifests the internal psychological resistance that a victim is feeling while being literally powerless to do anything to change that act. So listening to language, understanding it, and asking necessary questions to help us to better understand is also important to our work.
So one point I want to pick up on too, or add on, is the trained interpreter sensitive to the situation. And this is actually an episode I learned from when I was practicing as a prosecutor. Depending on cultural background, especially if you're talking about something intimate and sensitive as a episode of sexual violence, a female victim may feel less comfortable disclosing to someone of her own culture, depending on the gender of the interpreter. In a way, they might not feel as even more uncomfortable than disclosing to you, someone outside of their culture. So if there's issues like that that could make it more challenging for a victim to participate, be aware of that and try to accommodate or coordinate an interpreter that will accommodate the victim's comfort level as much as possible. Some additional tips, of course, using the victim's preferred name and respecting them with that is going to be incredibly important and critical. in any kind of case, and learning the victim's name, talking to them accordingly, and addressing them as that. The other thing you want to do, and again, I'm speaking mostly in the context, this goes for investigators too, but especially as prosecutor, avoid taking excessive note-taking, because again, putting yourself from the victim's perspective, if you're taking notes just for your purposes, it might just be because you're doing idly, something that helps you concentrate or focus. From the victim's perspective, you take notes intermittently, or take notes at one thing they said, and the victim's mind, oh, did I say something wrong? Is that important? And it can cause just a spiral. As much as possible, then try to be in a circumstance where you can record the interview if the details need to be remembered, or having a partner present, such as someone else in your office, maybe system-based advocate or community-based advocate, that can take notes and help you recall the details, so you can be 100% present in this conversation with this victim being there. If you are in a circumstance where you have to take notes, tell the victim why you're doing so. As much as possible with any kind of trauma-informed practice, you don't want to have something like there's like we're at a restaurant where there's a secret sauce that the victim can't know. As much as we can, we want to be transparent with the victim about why we're doing something, why we're asking something, and letting that victim know. And that's part of helping them feel safe and comfortable, and so that they can feel more at ease and trust us too. Part of it is also using relative terms, not, again, remembering that trauma can impair memory as well as other events, not trying to be specific about chronological narratives, but just narrowing windows. Was it light or dark outside? Not what time was it? And trying to understand not specifics of address, which is available, would make our case easier, but really that information might not be accessible by the victim, but by trying to make that question a little bit broader based. So this discussion here about recording or not recording a interview or a meeting, it definitely is a discussion good for investigators as well as prosecutors, and also especially applicable if you're having remote hearings or remote meetings with your victims due to lockdown pandemic restrictions as well. And we're not here to take an explicit position on it. I think most jurisdictions, at least in an investigative phase, and not only just with first responders wearing body-worn cameras, but with detectives and investigators having interview rooms, are leaning towards or falling into the recording area. And that has some obvious advantages, including better documentation. You're going to be capturing the victim's demeanor and tone. If you're trying to get in a memorialized version of a victim's statement through prior recorded recollection or something of that nature, or prior consistent statement or something of that nature, the recording provides a great vehicle to do that, because you can just play the recording and folks can see the demeanor. So it's a great vehicle for memorialization. Some of the concerns potentially can be potential technical difficulty and cost storing all this information and data, and challenges are certainly prevalent in being faced with the body-worn camera arena. But of course, recorded interviews, it takes a lot more time to prepare. And when I started lawyering in 1997, recorded interviews weren't the norm. When I joined AEquitas in 2017, it was the norm for so many cases, and they're wonderful tools, but it does increase the time to properly prepare a case. The other concern is if the technology to record is available, and in most circumstances it is, on no matter what the resources are, if an interview or meeting isn't recorded, there's an avenue of attack or strategy for the defense to pursue if someone's interviewed and the recording was available and it's not used. It can also have a chilling effect on the victim and the victim's ability to disclose if they know they're being recorded. Some victims may feel more comfortable with a recording, who knows? But it's something, of course, when it's being done, explain to the victim why it's being done, and the purpose of it, and not because they're not trusted. One question, and this seems a good opportunity to address here, a question we were asked is in a chat window is, in a domestic violence matter, compelling a victim to testify against a perpetrator, how do we help them with not re-traumatizing that person? This seems like a good juncture to sort of introduce some quick comments on that. I think that's going to be incredibly challenging to compel a victim to testify and not be re-traumatizing that victim. So hopefully what we want to do is that we have evidence-based prosecution and investigation practices so that the ability or decision to prosecute, it's not just resting on a victim's ability to participate in a case, and that we can try to proceed forward even if they're not able to participate through such thing as maybe a recording of an initial interview or initial statement that maybe we can introduce through forfeiture by wrongdoing if we can show witness intimidation or tampering by the offender. The other reason why compelling a victim is often not going to be the most productive strategy is because if they are compelled to participate, they're probably still going to be with the offender after that fact, but now they're going to be viewing the prosecutor and the authorities from an adversarial perspective, and they'll be less likely to reach out to help. And so for that future episode of abuse or violence, they're going to be less likely to reach out for help and less likely to participate in the system, which is why a lot of times compelling a victim to testify is usually going to be self-defeating. And we want to have practices and protocols in place that don't make that necessary so that we can still try to pursue a case otherwise as best as possible. So who should be present during an interview? Well, ultimately, you might have lots of different practices, and some folks can get kind of proprietary about it. But as much as possible, we want to let this be controlled by the victim as much as possible. In other words, at a minimum, if a victim can have a community-based advocate available with them, that's to be encouraged. And that's something that we should welcome, because the more support they have, the more that the victim is going to feel safe, going to feel comfortable, and not only suffer less risk of re-traumatization, but be in a position where they can better participate and maybe hopefully better disclose those corroborating details or information so that our case can be pursued. What can be more challenging sometimes is that maybe if a victim wants a friend or family member available, sometimes, and this is part of what it means about not just saying yes or no, which is non-trauma informed, but talking to the victim about some of the concerns or trade-offs with that. If our victim made a prior disclosure to this friend or family member, we might need that person as a potential witness at trial. And their ability to be effectively presented as a witness could be compromised if that person is also present during a victim's description of the episode or description of the incident, or could expose that person to impeachment. Like, aren't you just saying what you heard the victim tell the prosecutor, tell the investigator? And that can cause risks to the case and ultimate goals. And these are things we should talk about and try to explain in a victim-centered way, and help the victim to understand some of those concerns and trade-offs, and have options and alternatives available. And so these are the concerns if maybe your mom's sitting in on the interview. But one of the things, if maybe we have someone from an advocacy organization, they can sit in, and they wouldn't otherwise be at risk of being a witness.
So we turn now to recreating the reality of the crime at trial. And this builds upon everything that John and I have discussed with you about putting together a trauma-informed approach that's flexible and is very victim-centered, as we've discussed. What we're going to be doing is eliciting sensory details: sight, sound, touch, taste, and smell. There are two reasons for doing this. First of all, this can give us viable and valuable evidence to present, along with the emotional response and the physiological effects of the response, but it also is a great connection point with juries. What juries do when they're assessing evidence and when they're trying to determine the credibility, for example, of a victim's testimony, they try to put themselves in the position of the victim in an effort to try to understand the victim's testimony. Many jurors have the senses of sight, sound, touch, taste, and smell, or a majority of these senses, and they're using their personal experience to try to relate to the jury. So we may ask a victim, for example, were you able to see his eyes when he came towards you as you've described for us? Yes, I was. Well, can you describe what his eyes looked like then at that point in time when he was coming towards you? They looked mean, ugly, angry, hateful. These are just a few of the descriptions that victims have given of offenders' eyes, even when they have previously known the offender in a relationship or an acquaintance. And it's interesting, the next question is, when you saw his eyes like you've described, they were mean and hateful, as you just told us, were you able to tell us how you felt at that point? I was scared. It wasn't like anything I had ever seen before. How did you feel then? Well, my heart started just pounding really bad. Let me give you another example from a trial. A victim testified that an offender held his hand up to her throat. And I asked her on direct examination, as he held his hand up to your throat, are you able to describe for us how that felt? And she said, well, it was like it went all the way through back to the back of my head. Well, his hand had not penetrated her throat, but that was a traumatized expression of the sense of touch. And I asked her then what was in her mind, using double direct, when you tell us that he put his hand up to your throat and you almost could feel it in the back. I thought I was going to die. I thought he was going to kill me. And that is the testimony that resounds with so many victims of sexual assault, regardless of whether they knew or did not know the offender. And then I asked the victim, again restating the information that she had provided, when he held his hand up to your throat and you could almost feel it in the back, you told us that you were fearful of death at that point. How did you feel then? Well, it was like there was a darkness, and it was like it was just covering me. And, you know, there were lights on in the room, but for me, everything was just dark, bringing forward a physiological effect as well. So, as he moved towards you, were you able to see his eyes, describe his eyes? Do you remember hearing any sounds outside? Well, I can remember that I could hear a dog barking. And what was in your mind when you heard the dog barking? Well, I was just hoping that maybe the people next door were coming home, because that's when the dog always barked. Maybe they could come over and maybe somehow this would stop. It gives us valuable information from a victim when they're able to access that sensory memory, the smell of the person's breath. And then a question that's always impactful to ask a victim on direct, you know, when did you first feel like you were in danger? And that's a very interesting question, because it takes a victim to a signal point in the sexual assault. And it really heightens our ability to come to better understand that experience, and also to bring the jury into full understanding of the reality of this crime, although in a secondary sense. John and I didn't invent this word, but we wish we could have, because it truly is magic. Using this word in an interview takes all of the burden off of the victim. What it really conveys is, we understand the trauma. We know that you have been through something life-altering. What are you able to tell us about what happened? We've basically expressed all of those affirmations by using this one word. And the other thing that it does for us as professionals that's important, it allows us an opportunity to hear from the victim what the experience of the crime was, not interrupting it. I know some of us are in jurisdictions where the court may not always permit a narrative. And so what we'll be doing, if we're doing this on direct examination at trial, is at significant points we can ask supplemental questions so that we won't get the narrative objection. But what are you able to tell us about what happened? It takes the burden off of the victim. It frees us up as professionals. We don't have to be back with our legal pad looking at an outline, but we simply allow the victim the freedom to speak, and it opens us up to a better understanding of the crime. Sometimes victims may say, I'm just not really sure, I can't remember. And that can be due to the impact of trauma as well. And we need to tell the victim that if there are things that she cannot remember, that's fine, that we understand that. It also allows a victim to be as free from pressure as is possible when the victim is answering questions. What we want to do is to make sure that we're allowing the victim the fullest and fairest opportunity to describe their experience with the crime. And it also communicates to the jury at trial that if a victim is not able to understand something, but is able to talk about the corresponding events, that they may also be seeing a very eloquent example of trauma. I can't remember what he said, but what I do remember is how scared I was because I didn't know. I didn't know what was going to happen to me or what was going to come next. So when we put it in the context of the experience, even an inability to communicate all details can be important as it runs directly to the causation of trauma at the hands of the offender. So trauma-informed questioning using ABLE communicates to a victim that we understand, that we recognize the impact of trauma, and that it's also okay if a victim is unable to remember something, and maybe the victim will be able to remember it later on in testimony when there's something that draws her back to that particular event. That it's always okay to say that, it's always okay to say, I don't know. And I go back to the respect and the common humanity that we share with victims. There is never a right or a wrong way to answer a question as long as it's the truth. And that's the touchstone that we share with victims and with other professionals. Whatever that testimony is, we can bring it to the fullness of vitality, if you will, in communicating the reality of that crime to a jury.
So another strategy for trauma-informed questioning is going to be the funnel approach. And what is the funnel approach? But it's essentially what it implies. It's asking questions broadly and then narrowing it down to more specifics or more narrow topics. So what it's composed of is going to be the open-ended question, the closely related closed and follow-up question, as well as a summary. And this can be good in meeting with the victim, in addition to preparing, introducing the victim's testimony during trial, during direct and or redirect examination. Now, the most critical component of the funnel approach is going to be the open-ended question, where you're simply inviting the victim to volunteer as much information as they can, or as I should say, as they are able. And this is great trauma-informed because it's recognizing with that open-ended question that not all the memories might be organized, there might be gaps, they might not all be there. So we're finding out as much as we can. What's critical though is because a lot of times in response to the open-ended questions, the memories are really being accessed by the victim for maybe the first time since the traumatic event. So we want to be careful not to interrupt the flow of information coming from the victim that's being disclosed. Afterwards, we can ask closed questions that look for clarification about some bit of information that was offered or learned during that open-ended answer or that open-ended question. And these are what the closed questions are. We're just looking for confirmation of something that was implied or suggested or unclear from the information provided in the open-ended response. There can also be time for follow-up questions, and this can be challenging if you're not a note taker, but as much as we can, we want to keep memory about the things we want more detail or information on afterwards and be following with these questions and these queries. A summary, it's similar to the reflective questioning that Patti was talking about earlier, but after we're done with an interview or a segment of the interview that we're talking about, we want to review what we understand the victim to have disclosed, the facts and feelings, and make sure we understand that we are confirming with the victim whether we're understanding or heard correctly, and give the victim an opportunity to clarify and or correct or elaborate with us. And also making sure to invite the victim to ask us questions and to give them some agency in that sense.
Inconsistencies. Sometimes they've actually been viewed as challenges in a case, but they also can form part of the reality of that crime. They can result from the trauma that the victim has undergone, maybe the way the questions were asked. Maybe a victim was questioned by a first responder, and during that period of time, her immediate concern was for her life because she was making a report after she had been threatened with serious injury or death. And there may be inconsistencies there. The victim may have been asked questions calling for a chronological order. What happened right after that? What's the next thing that he did? And the victim is trying earnestly to fill in those blanks and provide that information, but the order may not be entirely accurate. And so again, we've used that word able advisedly to keep us away from the chronological questions that in so many cases really do lay the foundation for the claim of inconsistency. Sometimes a victim is afraid to disclose certain details, fearing that she may not be believed on certain points. And many times victims disclose in layers. I had a victim that I had worked with over a period of 2 years, and the victim actually provided additional information from the witness stand. And you still need to be open to it even at that point in time. It is a process, and at every point of that process, a victim is trying to recover from trauma, at going back to what happened and describing it for us and for a jury. If there is something that is inconsistent in an interview, we recognize the Brady obligation. It's important to have a witness in the room as well so that the witness can provide a summary for us to provide to the defense of any testimony. And rather than determine what is material or what is not material, I think it's important to provide information. We don't have any concern with what the truth is. And if this is an inconsistency from trauma, we'll be able to better explain that. So let's look at inconsistencies as part of the reality of the crime. It may be because of trauma, but it should not be considered a problem with a case that could somehow dispel our opportunity to secure justice. We need to put that in context as well. Going forward, we've talked a lot about recognizing the signs and symptoms of trauma. We talked about common expressions of trauma, but we still respect and know that many different victims are impacted differently and express trauma in a myriad of different ways. We need to be mindful of that and open to it. And during these interviews, we need to be fully present in all our humanity and compassion as we allow the victim a true opportunity to describe the experience. When we ask the victim about the experience of the crime, we're going into an area where advocacy support is very important if the victim makes that choice. We're asking the victim to go back to a crime that was highly injurious, physically as well as psychologically and emotionally, and support is a very good idea. We can do this virtually. We can do it through social separation in current settings, but the important consideration is that we are fully present and not just hearing, but listening to all information that the victim is able to provide. As we develop the sensory details of the crime from the victim's perspective, from her experience, we inquire also into the psychological response, the fears that the victim had at that time, and very frequently we'll also find a physiological response. In this way, we can help link the trier of fact, the jury, to the victim's experience of the crime to better understand the credibility of the victim. We do this work proudly in a time of great challenge due to the COVID pandemic, but as we began, this webinar focuses on several challenges, but also, probably more importantly, the opportunity that we have to do justice for victims in a time where all of us are challenged. We now have the opportunity for even a new beginning in the work that we do as prosecutors and allied professionals. I want to thank everyone for participating today. It looks like many of you are still here. This is my contact information. Along with my colleague John and my other colleagues at AEquitas, we would all be honored to respond to any questions that you have or any requests for technical assistance. Wish you the very best with all of the work that you're doing for victims in your communities, and would like very much to hear about the success that you're able to obtain for victims. Thank you again, and stay safe.
I just want to echo what my colleague Patti Powers said. Thank you everyone for participating and for joining our presentation today. I hope it was informative and helpful to you. And if there's specific challenges or issues you have that we could assist with, we'd be happy to do so. And also please check out our website, equitasresource.org, which has a lot of resources in a variety of areas that may assist you in your practice. I have time to stay online. If Cynthia, if you do, if there's any additional questions, I can stay and receive them. I'm not sure about Patti's availability.
Sure.
But I want to give that opportunity to everyone if Cynthia is available.
Sure, and I'm available all